All right. We are live. So this is Chris Berry with Castle Wealth Group, certified law attorney, certified financial planner. And we do these weekly webinars every Wednesday, or almost every Wednesday at 1 o'clock. Really just answering questions people submit ahead of time or clients submit uh, either ahead of time or live on the webinar. So typically there's not any formal presentation or PowerPoints or anything like that. And I always start with positive focus, just something positive that's happened over the last week. And had a great Thanksgiving. Visited my wife's family up north in East Tawas. And my positive focus is it was a good week for football if you're a football fan. So Lions squeaked a win thanks to some inept coaching by the other team, and U of M actually got a win also with some inept coaching near the end as well. So we benefited. Thankful for bad coaching. So we'll take that. And then with that, we'll go ahead and get started. And we do have some questions that are submitted ahead of time. And what I'll do is I'll take them and then plug them into the whiteboard and then go ahead and answer. So I'm going to share my whiteboard here in a second. Now we should be seeing a new screen and first question. So I'm kind of summarizing this question big time. Uh, but the question was, with regards to estate planning, we're married, we have one daughter, we've named her as a beneficiary of everything. Uh, do we need a trust? We have her as a beneficiary. We could do a ladybird deed, which says the home avoids probate and can go to her daughter. So do we need like a formal estate plan? Can we just download forms off the internet? Um, well, yeah, you can do whatever you want. Like you don't need an attorney to help you with these things. Uh, but uh, understand you get a lot of times you get what you pay for. So one of our best referral sources is people doing this themselves or downloading forms off the interwebs. And then once we review them, they see all the issues that we have. So for example, a lot of times I see a power of attorney people have downloaded off the internet, but Michigan has made some changes in law that invalidates that financial power of attorney, or uh, it's not it doesn't have enough teeth. Like there's not enough legal authority in that document. Like our financial power of attorney, it's about 20 pages. So it's not like we're killing trees or paid by the word. It's that we found that we need to include very specific language in there. So yeah, can you download forms? But you can, but is it the right tool for you? That's really where the value of an attorney comes into play. And then the question is like, all right, we have one daughter. Do we need a trust or do we need an attorney? And I guess it depends on what your goals are. And so we always focus on first, what are your goals? And then develop the best strategy to help you achieve the goals and then pick the right tools. Because all of these are just tools. It's just depends on what's important to you. And I would say for a majority of my clients, their first goal isn't just to avoid probate, but one of the reasons that a lot of our clients retain us is not to just avoid probate. That's kind of the estate planning piece, but it's also protecting your daughter, protecting her from divorces, creditors, bankruptcies. Because if you name her outright, and we talk about this in our workshops, if you name someone outright as a beneficiary and you pass away, they inherit this money. What happens if they get divorced? Half that money could be lost. Or what happens if they pass away? All that money could be lost going to a spouse who might remarry versus going down to grandkids. Or maybe you're concerned about asset protection for you, protecting you from long-term care costs, things like that. So yeah, if your only concern is avoiding probate and everything going outright and you don't want to protect your kids or loved ones, then maybe you don't need a trust. But really, that's where when we sit down for that initial visit with clients, we try to figure out what are they trying to accomplish and then figure out the right plan. And not every client that sits down with us gets a trust. It really just depends on what their issues are. I sat down with a family yesterday at our Livonia office. Uh, Not a ton of assets, but they had a home. And in that situation, we did a will-based estate plan with powers of attorney and a well-drafted ladybird deed. So that estate plan is gonna achieve their goals. So uh, can you do estate planning kind of without an attorney? The answer is certainly yes. Um, and in fact, we have some tools to help people if they don't really want to work with us. But yeah, for most people, most of our clients, they want to work with an attorney. All right. Next question here. And let me put it into the whiteboard. All right. So here is the next question. And there's a lot to this, but all right. So it's my understanding that people under the age of 49 may contribute a total of up to $7,000 to IRAs. That's correct. After or age 50 and above, there's a catch-up provision where they can contribute more. Scenario: a person contributes 3,000 to their employee IRA. So we need to clarify, this isn't an employee or employer IRA. This is an employer-sponsored plan, so this is going to be a 401k, 403b, something like that. That is different than an IRA. These are employer-sponsored plans, so they're plans the uh, from your employer versus an IRA is an individual retirement account. So a traditional 401k, 403b, 457, things like that, those are employer-sponsored plans. Those are not IRAs. And so here we're talking about $7,000 to a non-employer IRA. So the way the IRS treats these things is they keep them separate. So you're going to have your employer-sponsored plans where you can contribute, I don't have the number in front of me, like $24,000, way more than IRA. And so the question is, if you contribute a little bit to your employer-sponsored plan, does that limit the amount you can contribute to your independent plan? And the answer is no. So you could contribute $7,000 to your Roth IRA or your IRA. That is not the employer-sponsored plan. But then on top of that, you can also contribute to your employer-sponsored plan like a 401k. So those are two different contribution rules. And even if there's the employee match, like that does not affect your contributions to the employer sponsored plan. So it's two different things. So you have a $7,000 limit for your IRAs, and then you can have your employer sponsored plan. So the amount you contribute to one does not affect the other. Okay. Also on the back end, it works the same when you're taking out required minimum distributions, RMDs. So once you're 73 or 75 and you're forced to take money out, for tax purposes, these are separate accounts as well. So you can, like if you have 3 IRAs, you can combine all those IRAs to calculate your RMD, and you can take it out of all 3, or you could take it out of one IRA. If you still have an employer sponsored plan like a 401k, that would be a separate RMD. So you could not combine all the RMDs and just pull it from the IRA. You'd have to take out an RMD from the employer sponsored plan, and then RMD from the IRAs. And so that's one of the reasons, especially as we retire and we separate from employment, a lot of times we're pulling money from those employer sponsored plans, putting them all into an IRA just to simplify things and simplify the RMD rules. So not only during accumulation phase does IRS treat those types of accounts differently, your employer sponsored versus the IRA accounts, but also in retirement, as you're forced to take money out of these accounts, they're treated differently as well. Okay. Thank you. That was very helpful. Thank you for the compliment. All right. I see some questions coming in. I have a couple more submitted ahead of time. Give me a second here. So this will be a quick one. It's talking about funding assets into a trust. And we always talk about how a trust should be funded. And it's very important. It's not just important to have a trust, but you need to make sure you have all your accounts and assets titled in the trust. Is there anything that you don't directly put into the trust? Automobiles, typically we do not put in because there is a exception at the Secretary of State where if the value of the automobiles are less than $60,000 fair market value, then next of kin can walk in with a death certificate and sign an affidavit, and they'll transfer it to next of kin, thereby avoiding probate. So typically with automobiles, we keep those out of the trust, but everything else really, in terms of anything that has title, whether it's real estate, bank accounts, checking, savings, investment accounts, 401ks, IRAs, one way or another, we want that pointing to the trust. And this is something we've been talking a lot in our workshops, because we see people make mistakes on this. Make sure you have beneficiaries listed and you have these accounts pointing to the trust, even your cash accounts, like your bank accounts, your checking, your savings, your high yield savings account, your money market accounts. Make sure all of those accounts have beneficiaries, and typically we want that flowing to the trust. Too often we see families have beneficiaries on the big stuff like the IRAs and the 401ks and life insurance, but they forget to name the bank accounts. Make sure there's beneficiaries on those accounts. And at the bank, it's called either transfer on death or payable on death, TOD or POD. Means the same thing. It's just a beneficiary designation for your cash accounts. So um, make sure you have beneficiaries on those cash accounts, whether it's pointing to the trust or pointing to individuals. Ba, ba, da, ba, ba, ba. All right, a couple more questions coming in, so I'll get to those in a moment. This is the last one I had submitted ahead of time, so let me take care of this one. All right. So could you explain what Medicaid crisis planning is? Um, and so this was a follow-up question to last week where we talked about planning ahead for long-term care and planning ahead for Medicaid. And Medicaid is a governmental program that can pay for your nursing home care. To qualify for Medicaid, a single individual can only have $2,000 worth of countable assets. Married couple at most can have about $150,000 of countable assets. Countable assets are everything other than a home, small cash value of life insurance, personal belongings, prepaid funeral, and an automobile. Everything else is a countable asset. So your IRAs, your 401ks, your annuities, your spouse's accounts, all of those are countable assets. And then Medicaid looks back 5 years to see if you moved any money around, and if you have, they're going to penalize you. So one of the pre-planning strategies, and the strategies many of our clients utilize, and in fact, we're kind of doing planning for next year, and we're looking at our numbers from last year, and the majority of our clients, more clients did asset protection trusts with us than any other type of trust last year. So we actually ran the numbers, and the majority of our clients were doing what we call castle trust, which are asset protection trust that as soon as you set up the trust, you move the asset into the trust, it starts a 5-year race where if you can make it 5 years before you need nursing home care, everything inside of the trust is protected from that nursing home or Medicaid spend down. So we actually ran the numbers for this year, and we did uh, more asset protection trusts than any other type of trust combined. Um, and that's what elder law is about. That's why people look to us as an elder law attorney. Estate planning is just planning for what happens if you die. Elder law is planning for what happens if you don't, and you face all the issues go along with aging. Making sure your money lasts as long as you do, protecting against long-term care costs. That's also why I'm a certified financial planner, to make sure your money lasts as long as you do. So elder law is planning for what happens if you don't die and you continue to live, right? Uh, so pre-planning, that's where a lot of times we set up the asset protection trust, we move the assets into the trust, starts that 5-year race. But as a certified law attorney, we also have what we call crisis planning. So this is available. It's kind of in our back pocket. We don't like to rely on it, but this would be a situation where you have a loved one in a nursing home right now who's paying $10,000 to $15,000 a month. And let's say they do have assets. Maybe they have $500,000. And so one option is you pay $10,000 to $15,000 a month until you get to that asset limit, and then you can qualify for Medicaid. Or the other thing that we have available as certified law attorneys is we can do what we call Medicaid crisis planning. And this is where they're always moving the cheese on us or changing the rules versus planning ahead. Like the government doesn't really penalize people who plan ahead. Like they've changed the look back period from 3 to 5 years back in 2006. But when they made that change, they grandfathered in any prior planning. So the government doesn't really come down hard on people who plan ahead. But when it comes to planning at the last minute, they're always kind of moving, kind of changing the rules on us. But big picture, the way it works is that if you did have a loved one in a nursing home now paying $10,000 to $15,000 a month, there's things we can do right now to protect roughly half of the assets. And so we call it a half loaf plan. Think of it like a loaf of bread. Half the money might have to go to the nursing home, the other half of the money we could protect. It's kind of complicated how we do it. There's a couple different ways that we do it. One is using very specialized types of trusts, uh, which in the past Michigan has come down on. Michigan is allowing those now, but it's still kind of risky of whether we use those. types of trust, or we can also use some other strategies. But big picture, think of it as if you do have a loved one in a nursing home right now, there's things we can do even within the 5-year time limit to protect at least half of the assets. It's pretty complicated, pretty time consuming, pretty stressful to get it done. Uh, and but it is possible. We'd much rather plan ahead where we can protect up to 100% of whatever's in the trust versus the Medicaid crisis planning where we can protect maybe 50% depending on the situation. So, but that is complicated work where for sure you'd want to work with a certified law attorney. This isn't something you'd want to kind of go at on your own. All right, here's a couple questions that came in as I was talking, and let me see if I can share these. Not sure if it'll let me share it the way I want to. So give me just a second. Yep. All right, cool. All right. So are you familiar with investerefi.com? I actually had to Google that. So the answer is no. But what it is a platform, and we would consider this an alternative. So there's lots of different types of alternatives out there. So what this is a platform that invests in kind of like student loans. So it's like a second party student loan investment. And so I would consider this an alternative type investment where make sure you have a certain level of assets before you even consider it, because this is a good way to look at differentiate or diversification. But I certainly wouldn't want to have all my whole nest egg in something like this because, and I'm not saying specifically this type of investment, but any of these kind of alternatives, this is where typically in the past we'd recommend like 0 to 10%. And there's a lot of research showing right now that instead of that old style like 60-40 portfolio, 60% stocks, 40% bonds, or kind of some variation of that, what we found is bonds haven't been that kind of that seesaw or that diversification where I thought it was. And so now there's a lot of research and statistics saying that really, if you're looking for a well-diversified portfolio, you should have maybe around 10% of your investments in some alternative type vehicles, whether it's something like this, where it's investing in like student loans or real estate. And we even have some funds that are open and liquid where we can pull in alternatives like gold and silver, or whether it's Bitcoin, but it's just this kind of like alternative world. And so the question is, can that be put into an asset protection trust? So with any of these different types of platforms like that, another example would be like a Robinhood or a Coinbase, where you have to, and again, I didn't do a lot of specific research on that specific platform. But if you have to go through that platform to invest in it, it's going to depend on that plan administrator, if you will. Versus if it's like an openly traded fund that we can trade at any custodian like Charles Schwab or Fidelity or Altruist, where I can make a purchase and purchase that security or purchase that ETF or purchase that alternative investment inside of any of the normal kind of big custodians. If that's the case, if it's at a custodian, then yeah, it can be part of any other type of account. And if we have an asset protection trust, then the trust can be the owner of that account. But if we're having to invest in whatever that investment is through like a specific website or a specific plan administrator, like Coinbase, for example, I'm not just trying to single them out, but I just familiar and have dealt with them in the past. It's going to depend on whether they'll allow trusts to be owners or trusts be beneficiaries, or even to allow beneficiaries on those accounts at all. I know when Coinbase first came out, they didn't allow any type of beneficiaries. Like if you passed away, it's going through probate. You couldn't even name a kid. And it sounds crazy, but understand even like I-bonds have some restrictions on who you can name as beneficiaries. Like you can't name a trust as a beneficiary of an I-bond. So for each of those like alternative type investments, if you're investing through their specific portal, you're going to have to, or we can help you if you're a client of ours, and typically it'll be in like the frequently asked questions. You'll have to figure out whether you can open up in the name of the trust, or you can name a beneficiary on that type of account. But if it's something that's invested at a normal custodian, even if it is an alternative, like we have like gold and silver funds, and we have real estate funds that we can invest in our custodian that can be part of an account, that part's easy. So yeah, that is that. All right, here's another question. So give me a second. Let me copy this. And I'll put it right here. Text. Boom. Boom. Income tax question. Is taxable income determined or before or after standard deductions? So with regards, we call it marginal, or your marginal income tax bracket, your final tax number. There are certain calculations that is prior to the standard deduction, but really when we're talking about like Roth conversions or trust conversions or anything really important, we're taking into account the standard deduction. Okay. And it'll be interesting to see what happens with that standard deduction based on what happens with the Tax Cuts and Jobs Act, which is set to expire next year. That said, it could be extended, but we have no idea what's going to happen. Next year is going to be an interesting year from a tax perspective. I'll tell you that. A, because we're $36 trillion in debt, and then B, the Tax Cuts and Jobs Act is set to expire. So I think coming out of first thing that I'm looking at in terms of kind of where things are going to go starting next year is going to be taxes. They're going to have to do something. And chances are taxes are not going to go down because we're $36 trillion in debt. How about annuity RMDs? If one has both an annuity and traditional IRA, does one have to take out 2 required minimum distributions? Well, so understand typically you're going to look at annuity. That's an investment tool. And I was having this conversation with some new team members in terms of training. The way that I look at investments and how things are titled and the rules typically is first I look to what bucket are they in. And so there's 3 main buckets from a tax perspective. We have non-qualified accounts. So this is post-tax money where if it grows, potentially you'll pay capital gains. Maybe, maybe not. And with this non-qualified post-tax money, it goes to the next generation tax-free because of step up in basis. If an asset is owned by an asset protection trust, it falls into this non-qualified bucket where we can leave it to the next generation tax-free. It can be asset protected. And for our clients that have asset protection trusts, that's where we want most of that money is in that non-qualified bucket. The second type of bucket, and this is the worst type right now, where a lot of our clients are trying to move money out of this bucket. The second bucket is tax deferred money. So this is money that whenever you pull it out, you're going to have to pay income tax. So this would be like traditional IRAs, traditional 401ks, 403bs. This is tax deferred money. And if we all agree that taxes are going up in the future, having a lot of tax deferred money right now isn't ideal. But it was beaten into our head, defer, paying taxes as long as possible with the assumption that we're going to be in lower tax bracket in retirement, which we find a lot of times we're not. We might be in the same tax bracket, but on the lower end, or sometimes even the higher end. And then third type of tax bracket is tax-free. And this is going to be Roth money or cash value life insurance or 529s that have to be used for education or health savings accounts. A nice thing about this is that it grows tax-free. So understand that those are the 3 tax buckets, and a lot of the rules, and especially rules regarding required minimum distributions, they're not based on the type of investment. They're based on the type of an bucket it falls in. And so an annuity, while can be a little bit complicated, typically it's just a type of investment like a stock or bond, and it's going to be in one of those 3 buckets. So if the annuity is inside of an IRA, so if you have a fixed index annuity inside of an IRA, then it falls in the IRA bucket. And it whether it's in the market, like if you have an account at Charles Schwab, that's an IRA, if you have a security benefit fixed index annuity that's an IRA, you can take all the money, all the RMD out of the annuity if you want to. You can take all the RMD out of the market, the Schwab account if you want to. So because it's all inside of the IRA, it's all part of one bucket. Now inside of that tax deferred bucket, you can also have the pre-tax 401ks I was talking about. That's different than IRAs. Okay. You can even have an annuity inside of 401k, like TIA Craft. They're known for kind of sneaking in annuities inside of the pre-tax account, employer-sponsored plans. But again, with regards to the RMDs, it's just going to be 401k or IRA. It doesn't really matter what type of investments are inside of those. Okay. Your webinars are very interesting. Thanks. I see a YouTube link in the upper left of the screen. How can I access past webinars on YouTube? Well, you can go to, we have a YouTube page. Like if you go into YouTube and you just put in like Castle Wealth Group, we should pop up. And it has all of our past webinars, and I have someone that kind of breaks these into like little snippets and stuff too. So I actually just had a call this morning from someone that found us on YouTube. So I appreciate that. All right. Other questions? All right. Assets from the state to avoid losing. Okay. All right. So this is last question. It looks like it's kind of submitted twice. So all right. So here we go. Could you put your estate from your parents in trust so you don't lose SSI? So with any type of like governmental benefits, and we have a lot of clients, well, not a lot of clients. We have clients. I had a woman even last night at a workshop. She raised her hand and said she has 2 children who are adults, but they're her words, special needs children. So they're receiving governmental benefits. So one of the things that we have to do in situations like that is we need to set up what we call legacy language inside of a trust to say that if anything is going outright, or if anything is supposed to go to someone who is receiving governmental benefits or may receive governmental benefits in the future, then instead of going outright to them, it has to be held in trust for their benefit. And in most of our trusts, or I think all of our trusts, we build in language where there's a toggle switch. Because in our experience, like we found that we can't always predict like every situation, like looking at the crystal ball, we don't know what's going to happen. And so just like we build in language, so if anything's going to someone who's a minor, instead of it going outright to them, in our trusts, and again, this isn't in every trust, and this is, again, why you want to work with an attorney versus downloading some form. But in our trust, we build in language like a toggle switch. So if any of the beneficiaries are receiving governmental benefits in the trustee discretion, they can flip a toggle switch where now instead of it going outright to them, it could go to them in a supplemental needs trust where now they can still receive their governmental benefits, whether it's SSI or whatever it may be. But now there's a pot of resources managed by someone else that can be used to improve that person's quality of life. In fact, I had clients, we did their estate plan in 2000, we updated in 2016. He passed away this year. One of the beneficiaries is a supplemental needs individual. And so I was talking with the trustee on how we have to set up this separate trust where instead of it going outright to the daughter, it's going to be held in trust and he's going to manage it. She's going to still receive those governmental benefits she's entitled to, but now there's a pot of resources to improve her quality of life, to pay for vacations, things like that. So yes, there is a way where if you are inheriting money from your parents, it could be sheltered from you losing any potential governmental benefits. Plus, a lot of my clients build in language to say that it also shelters or protects their kids from divorces, creditors, bankruptcies, make sure the money stays in the bloodline. If you've attended any of our in-person workshops, we call this the Fred situation, where you have a daughter and you have the son-in-law, Fred, who hasn't had a job since 2009, belongs to religion you consider a cult, sells t-shirts at concerts by a band called Fish. You think he's fond of chemical substances. He thinks it's great he has rich in-laws. So if you're to leave this outright to your daughter and then she passes away, that money all could go to Fred. versus going down to your grandkids. But with proper trust planning, we can build in this legacy language. So now whatever your kids inherit can be protected for their lifetime from divorces, creditors, bankruptcies. If they are receiving governmental benefits, we can protect that. If they're minors, they can be protected. Yeah, that same situation I was talking about with the daughter who has supplemental needs. Some of the other beneficiaries are grandkids who are minors. And so this one trust the individual set up is going to split into separate shares, one share for the daughter who has special or needs supplemental needs, one share for the son who's the trustee, and then he carved out money for the grandkids who are minors, and now the son will be the trustee of those. So yes, with a trust, we're creating your rule book. And that's why a lot of our clients, not everyone, but a lot of our clients do look at a trust as the focal point of their estate plan. So, all right, great questions this week. I do appreciate it. We had a good number of people on the webinar today, so it's good to see some familiar faces. I do see you. And with that, make it a great week. Take care. Bye.